94.7 Asempa FM Sony, some 30 minutes after 2 on Ghana's #1, the most authoritative political, social, current affairs talk show, Ekosi saying live on Asempa FM, meeting your say Bunsu from Yobi. Yet not to say at 6:30 p.m. and media neighbor any ukriada, the midweek edition of the show is live and airborne. Please tell a friend to tell another friend to tune in to 94.7. Ekosi saying soon. We are live on Facebook, live on Instagram, live on Twitter, live on YouTube. Please join us and let's stay interactive. And some go up on sono door. So of course the big story, the Supreme Court ruling Abba Efa Asen North Member of Parliament and the declaration from the Apex Court of the land. And yebekom onim says ruling bisa eba na opese wote emu asye ye bie ma hu whatever happened, the considerations are court make here and the ruling itself Asempa FM. So Ekosi saying so and our better no Joseph Akable atena sedada and the details of the Supreme Court ruling ebebremo enchebi animo who said enioma what this ruling means to one, the High Court ruling, two, processes are not air cost to a court of appeal, and they are then saying that is eti. And a free and air corner, what would happen in Parliament? Numbers necessary saying ABC, Aquakoye, and all of that. You better sound coming in every Ekosi saying so. I'll be speaking to some lawyers as well on this Supreme Court ruling. Lawyer Abraham Amaleba, who is the Director of Legal Affairs for the NDC, will be speaking to lawyer T Hammond, MP Adansia Sokwa, on also some very, very interesting points to make about this ruling and a end round Komani DFA and Sema Honorable Kan Dapaah a time we share judges and magistrates here in Ghana. Inti and Komo and 100 Dawson, and we have an interesting lineup just for you in the moment and so and then so some of our listeners are a war but ya no English ya man from oma kwan na after nsuo talk aka no matwa pictures ni videos they are sending hey na nkran pa na bi na makwan say so it's ehu we'll be showing you some of those videos na unso wehu and we encourage you say baby I will be and say bibi cost na free say ye bohu de ro na anu ye ne beba se de bia ye no fa send ye na ye ntu ho anamo emament ye de mo be ko botia no English ya man from. We'll show you the state of the road in that area. So area no kwa ye frɛ ho saying I mean it's a friend is saying po area ben new botiano new botiano ehu we'll be showing you the videos na mo hu said enioma AC air contimon so Ekosi saying the high Asempa Mamenda Abuafo na say Compute Ghana passion for technology lifeline properties Ena Agbeve Herbal Center Omone boy me the sound of our time April me hear some segment nso Cocoa Milk Ostek Properties osi ye nsasira Obapa product EcoBank Ghana and a Rockstars Roofing Systems. Yeah, interviews are here on this show. Asa Plus Destination, Sasem Pharmaceuticals, CBG, or say we stand with you, and a DBS Roofing Papa Efie. Your discussion segment here, the Bell Beverages, Refreshing the Nation, Weber Call, or say we care. Franco Trading Enterprise, Phone Papa Fie, Dependable Herbal, and a Emma Ross Limited. And you may call a boy me Ekosi saying Abraham. And please join us on Facebook. Now. Exclusive videos are one ye to me the nina Abramo Joseph Akable in court correspondent. Joseph, it is saying
Aboko
Bibi Ekoye
Anyamia do Aboko.
Great. Inti and then Supreme Court and then the PMO
and then unim no a case I go PMO Supreme Court a Michael and Common Nimfa. At the Kodan a year court no akache. The Ekosi ni say okay July 2021 the Supreme Court no a High Court a Cape Coast a release a year James Jechikwesi no he cannot hold himself as a member of parliament because of a year DAC wa answer mkoto aba no almost say filing a nomination forms no na or he is still a citizen of Canada. And in their view, he was not qualified to contest the polls.
Eligible
to contest. And the court ruled in the favor of Michael Ankoma Nimfa, nullified the elections and said he should not hold himself as a member of parliament. And on the strength of this particular matter, and the Assembly Court and Supreme Court Akachi, it's effectively asking the court to come to a conclusion that as at the time of filing a nomination form, on receiving a renunciation certificate, it meant he was not eligible to contest. Now, even before a court delay with that substantive issue, the court should grant an interim measure which will give effect to a year the decision of the High Court, Cape Coast High Court, to ensure that he no longer goes to Parliament. And that was the interim requester. Interlocutory injunction or Ocasio Court, and we've reported on different occasions about the arguments for and against court decision by. Now, in terms of the full reasoning, I'm catching to be available by close of day today. We've still been working on it. We don't have it, but what we have is what the court read today. Meridia, it says
read by
Justice Jones Duche, president of the panel. Say by a majority decision of 5-2. Doji and Amegacha JJSC's dissenting. The plaintiff applicant's application for an interlocutory injunction against the first defendant respondent succeeds. Accordingly, the first defendant, hearing James Jechikwesen, is restrained from holding himself out as a member of parliament for Asin North constituency, presenting himself and or attending before parliament to conduct the business as a member of parliament for Asin North pending a determination of this suit. The court further directs that the hearing of this suit be expedited and that the parties and their counsel will cooperate with the court in that regard. We have observed that the first defendant has filed processes including the statement of case on 12 April 2022 instead of 11th April 2022. That notwithstanding, we direct the parties and their counsel to endeavor to file their joint memorandum of issues on or by the 25th of April 2022, failing which each party may file their separate memorandum of issues for the court to compose the relevant issues out for them. And it ends by saying that the full reasons will be filed at the register of the court by close of day today.
A bit of clarity. Supreme Court said, Omu ruling when you pending the determination of the suit. A suit being
a suit Michael Ankoma Nimfa a file was Supreme Court in fact it effectively is asking the Supreme Court to interpret certain portions of the constitution. And then the point and now response Chachikata file I know make arguments and they say at every stage of the process now, right from the High Court, Michael Ankoma Nimfa lawyers in their view are taking the position that it doesn't raise any interpretation matter. In the afternoon, no one catch the Supreme Court and documents that they filed and say, how come all of a sudden they are raising this issue of interpretation and asking the court to speak on that matter? But as part of that request, they call court on, they also asked for interim measures that, as far as they are concerned, into one or more access a court and declare say, as at the time of filing to contest, because he had not received his renunciation certificate,
now
uneligible to contest, as has provided for in Article 94.
And na say no so the High Court ni rule on Cape Coast.
Cape Coast High Court. Na mbra mu raise lawyers for Jechikwesen can say omo refer matter to the Supreme Court.
Yes.
The High Court disagreed. They said it doesn't raise an interpretative issue and ruled on it.
Of course.
Until after High Court, Court of Appeal, they raised the same issue again. The Court of Appeal disagreed. Then it actually went to the Supreme Court.
Yes.
Then when it got to the Supreme Court also agreed with the Court of Appeal decision. Then this separate process, it came in January 2022. It does not, in terms of its direct specifics, it's couched in a different manner. But effectively asking for a declaration that he was not eligible to contest the post. Said the High Court ruling. Then, in addition to that, to saying that even before you deal with that particular issue, restrain him. So that matter is determined because they say that once there's a final court judgment from the High Court that says he's not eligible, it means that every single day that he goes to Parliament will be an Obum Brasso. It's a better side than court and restraining.
Okay. In Tissisiano, say because High Court in Cape Coast the ruling, you name for parliamentary election petitions, and they are the Court of Appeal. Say presidential election petitioner and at the court with the exclusive jurisdiction a Supreme Court. In the way a parliamentary election petition. After High Court ruling, processes be shall see our Court of Appeal. Eventually, Omubogui for non-compliance. And no, Omasia realistic our case.
According to what the Director of Legal Affairs for NDC. Abraham Maliba told us on Joy FM some time ago. So they've made that they filed those processes. But the process that I have seen, and normal filing was Supreme Court. Our Mubisa for certiorari just to ask the court say quash the Court of Appeal decision to strike out the notice of appeal. So that process I've seen. In fact, right after Supreme Court the mass decision we or and our journey proceedings to I think 13th of May.
13th of May
to deal with that particular one. Court of Appeal decision.
Decision now I'm the ball.
Notice of appeal.
Notice of appeal
because they are not complied with the directives are court. Had issued said that they should follow. In the
CCR, effectively, with this ruling from the Supreme Court, number one, James Jessiquason ain't me and friend who's a member of Parliament to be in the Ontime Parliament. Meanwhile, the substantive issue before the Supreme Court, a year interpretation of Article 94, and on the Omunya Maso.
No.
Or much a date, they said that Ben on bit Tenasa.
Then latter part of the America, they give the various orders about what should be filed and what should not be filed. They are adjourned indefinitely. So what mostly happens in that instance is because it is dependent on the ability of the parties to file whatever they have to file. So once all that is complied with, the registrar issues a hearing notice, then the parties are set. Yes. So for now we don't have a specific date for that particular matter. In
Tisebasa and the Supreme Court na sasem so. Na based on interpretation of the Article 94, as they've been called upon to do, Omoka say, na Jessiquason is eligible to contest her. What does it mean?
It will mean that one of the reliefs are, in fact, in the counter winning a response now, Chapchikata filing on behalf of Jessiquason. One of the things they are raising is if the court comes to their conclusion now, then the matter should go back to the Court of Appeal.
To the Court of Appeal.
Appeal to have it relisted. Then the Court of Appeal will have to apply that.
Apply, sir. Ruling from
ruling, yes, in terms of what they filed now. Yeah, the process normal filing,
Wow. But that would be interesting. Saying, sir, the substantive parliamentary election petition should end at the Court of Appeal. What the Supreme Court is being called upon to do.
It is under its original jurisdiction, interpretative enforcement.
I get
completely different.
I get you.
Then there is the natural court appeal process now. Almost delisted, they strike it out now. And then so almost use Supreme Court's supervisory jurisdiction over all courts, to try and set that one to aside. So they are like multiple parts moving. But I mean, this at least for now gives us a bit of, I don't know whether to call it clarity or not, because for now it means that let's say Parliament.
It's Nasia. 274.
Exactly.
This is 274. Jessiquason ain't mean Parliament.
In fact, any Attorney General already there, he takes the view that he doesn't actually see anything that restrains the EC from declaring the seat vacant. And that, in his words, or say, if not for, and I'm quoting him, or say, if not for the legal shenanigans now, there should have been a by-election in Asin North long ago.
Where
Attorney General Godfrey
Dame. Okay. On this ruling, money Chatuchikata didn't come.
No, we got to speak to Baba Jamal. Baba Jamal.
Or a member of the NDC
legal team. Or say, in fact, in his words, or say a sad day for Ghana's democracy, because believe he said the people of Asin North have been unfairly denied representation in Parliament.
I didn't hear.
Or see, because as far as they are concerned, there are various legs of the matter, including even at the Supreme Court, that is outstanding. And so the court, in his view, could have left the status quo to be, so that Anka Omuvia Nende Bibia by Vienna conclude say, I mean, whatever has processes have happened are in the right order. So he's no longer the MP, then fine. But because those issues are pending, he thinks that in the event those matters go in favor of the person, the period that we deny more representation, how do you compensate them for that? But Frank Davis, Michael Ankuma, Nimfa, lawyer, the response to that, and they say, the people of Asin North are better off without an MP than with J.H. Kwesi as the MP because he's not eligible to be the MP.
Eligible to be their MP. In TCC, said Wakano, in the ruling, no, Supreme Court can say, Emani Holdi Nehu Bio.
In fact, let's take that part again. I'll say the first defendant here in James J.H. Kwesi is restrained from holding himself out as a member of parliament for Asin North constituency. That's one.
Full stop.
No, comma.
Okay, comma.
Presenting himself and or attending before parliament to conduct the business as a member of parliament for Asin North.
Full
pending
stop.
The determination of this suit.
Pending the determination of this suit.
Suit full stop.
Can there then be a by-election?
The AG holds the view that nothing stops the EC from declaring the seat vacant. We also spoke to Abraham Maleba, whom you'll be engaging shortly on Joy Midday.
Yes.
He disagrees completely that he thinks they are completely far away from that because of all the outstanding matters, and even hinting that there's the possibility that they could go for a review because this is a 5-2 decision. In which case, if there's a review, two
will be added.
And so that will bring the number to 9.
Okay. From list time, the members of the panel, Justice Jones Doche, Honorary President of the panel, Justice Agnes Doji, Justice Nene Amegacha, Justice Mariama Owusu, Justice Gertrude Tokonu, Justice Professor Henrietta Mensah Bonsu, and a Justice Emmanuel Y. Kolendi. Inti yewie no 5-2 no omo ana a dissent in nature say omo ana omo ne dodo ne nya adwen no omo ye mienu ne ye Justice Agnes Doji and Justice Nene Amegacha. Into omo form a majority no included the president of the panel, Justice Jones Doche, Justice Mariama Owusu, Justice Gertrude Tokono, Justice Professor Henrietta Mensah Bonsu, and a Justice Emmanuel Y. Kolendi. And 5-2 no, and no. And unfortunately, they say yenya detailed ruling in Kanye. Into for 2 na dissent ye ni more reasons in tia or more day a dissent. Once we get it, ye nemo ebeche. But this is where we are now. Say say Parliament reconvene and there. And Sisiana Supreme Court, our journey case no Senate no. Yenim time or mobile befre. It means says Parliament reconvene and now a 274 members nebeko.
San Pepe. I just say as it stands no the NDC numerical strength no about 136 no.
About 136. Yes, now MPP 137. Now independent candidate back. Wow. And meanwhile no the criminal aspect I don't know
it is pending High Court.
Inti ebasa enne se Electoral Commission take notice na, but I don't know which would come first. Se Parliament nebe speaker nebe notify EC.
In fact, maybe Evans Mensah or say Mensah will string come on. He disagreed or no, or he holds the view that he doesn't think the speaker has any role to play in this. In commenting on what should happen going forward, he also limited himself to the Electoral Commission.
Okay.
Saying that as far as he's concerned, they should have even organized a by-election long
time ago.
Just that the legal issues that were, and he thinks that for now as he's speaking, he doesn't think there's anything that stops them from doing that.
Inti onono free say it was say EC no it take you over straight a declare seat no vacant na elections no assign ever.
But he admits that nonetheless the Supreme Court has indicated that the matter should be determined expeditiously.
Okay.
Then he makes the point that he holds a view that the Supreme Court's conclusion will not be any different from what the other courts have done on this particular issue, because he thinks that this matter was dealt with in substance in terms of the Zaneto case.
Yeah.
So he doesn't think that the court will come to any different conclusion, that the eligibility is not when the nomination form is being filed. But don't say, yeah, Mr. Jichkwese Molo, some of my arguments has always been that he performed the side of the bargain.
Now, on to control Canadian authorities on when they should.
In fact, or making reference to COVID-19 crash, and it took more than 6 months. The certificate had not even come, and it actually came after.
And I think Professor Kweku Azar also shares that
view as well.
View. Very
in fact, you know, more documents now filing in Campo. Portions of it come raise issue. And they say, Tama issue, you know, before the election, someone raised the issue with the electoral commission.
Yeah.
And the electoral commission's process, no more adjudication committee, they sat on it.
And so Emma all
clear to even go ahead.
I think one issue also of contention, say Omokase before the election. When is before the election? The argument has been say election no a process. Into nomination here they didn't election process now. It before the and that's also one area issue. About him say lawyer Abraham Amaleba Aba Homane so. Counsel akwa ba na pom to saying. Yeah, Danyamia say in NA from at least Kakrana Supreme Court, president of the panel, Eridi out, no. Can the EC go ahead and conduct a by-election in the constituency now?
The answer is no. Because OTA Supreme Court in Ankasa, almost the substantive matter has been adjourned sine die. What does that mean? Actually, say, assem, ewum, yenye. So how can the EC go ahead? In fact, it's not the EC. The EC might be notified by the clerk of parliament. So EC and Kasa cannot just stand up and go and do by-election. Yes. But in any case, we've not gotten there yet. We have to determine the matter to its finality.
But what it then means, Nese, if we are all waiting to determine the matter to its finality, you know how long that will take. Meanwhile, the Supreme Court decision will still hold. Say the honourable member of parliament, Ntimi Mfrene, who said, "Oye MPBO."
That's not what the ruling said. The ruling says that he has been injuncted from going to parliament. And yes, sir.
Apart from injunction, I can say he should not hold himself out as MP.
Why I can't, sir?
The president of the orders na ewa and Joseph Bessenya go through biona what this is what Justice Jones Duce reading out and yes.
Accordingly, the first defendant hearing, James Jechikwesen, is restrained from holding himself out as a member of parliament for Asin North constituency, presenting himself and or attending before parliament to conduct the business as a member of parliament for Asin North pending the determination of this suit.
Yes, lawyer.
So that's what I'm saying, sir. And then it's a sad day for our democracy because Oma ruling say you are denying the good people of Asin North of a representation, and this brings to the two groups of people who are being denied representation. I'm talking about Sal and this one.
Yeah.
And how can you call such a country as a democratic country when a chunk of your people are not being represented? In granting an injunction, the paramount thing is that you are trying to stop an irreparable damage, or in law, you better say an irreparable damage. In this case, Papa Way, he has been in parliament for more than 1 year.
Mm-hmm.
He's been in parliament, you know. How does that cause the good people of Asin North? Has anybody died there? Has anybody said, one year no, because question is in parliament? What is the irreparable damage that this ruling is trying to correct or stop? What wrong is going on in that constituency? So one would have thought, because of the representation of the people, the Supreme Court would have said that for the time being, continue to represent the people. And then when we finally determine the matter and you have to be taken off, we'll take you off. But Niamaya, is denying close to 30,000 people a representation in parliament. And that goes to add to south. And how can you call a country like that a democracy?
But lawyer, so the other angle, so even before the Supreme Court was called upon to determine, as they've done today, there is a substantive High Court ruling, which ruling seeks to declare, say, the honorable member was not eligible to contest in the first place, and or more, the plaintiffs, no, in this case, no, apart from substantive interpretation issue, they prayed the court to injunct the member of parliament as well. They call Supreme Court now. So what were we expecting the Supreme Court to do?
Let's go back to the High Court.
Okay.
I was a lawyer there.
Okay.
Me, Abraham Amaleva, me can say Article 94 2A. This interpretation at the Supreme Court. If you were following.
Yes.
Frank David opposed me. The High Court judge agreed with him. And then, almost say, they are in that same Supreme Court to interpret Article 94 2A. Me can, you know, and I'm telling me, Mojano, and Yakokono, it cannot be transmitted. But Omoka, then we'll go to the Supreme Court. And yes, sir. I raised this matter a long time. And they opposed me. Why? Our argument, say, colleague, you know,
yes,
or more you see Zenator to apply to this case. And we have been saying, sir, Zenator is different from this one. Because in this one, if you look at the People's Representation Act, Section 20, actually says the time for qualification is at the time of election. I've mentioned the law to you. I've mentioned the section to you. You are a law student. Go and check it. People's Representation Act, Section 20.
Mm-hmm.
The cutoff, the appropriate time to denounce or to be qualified to contest is at the time of election. I heard you say, sir, the election is a process.
No, I said, sir, there is a contention because Ebiaka said at the time of election, no, when exactly is the time of election?
Exactly.
Mm-hmm.
Let's even assume that we all don't know that at the time of election is 7th December 2020. Let's assume that we don't know.
Yes.
Why are you starting the time of election to be the time of nomination? Why not the time that we call people to go and line up and register and write their names in the register?
Mm.
That time is not part of it.
That's a fair point to make. It's a fair point to make.
So when you look at all these things, I have a sore throat, or that's why I'm talking that way.
Sorry about that.
When you look at all these things, the way this matter is being treated, it's not fair. As we speak, people are comparing it to Adamu Sakande. Adamu Sakande was sitting in parliament while having dual citizenship. He didn't even initiate the move. Say, I'm going to denounce the other one. But Papa, before you and me went and queued on the 7th December, he had denounced the citizenship of the Canadian one. And so I think that the people of Asin North have been given a raw deal from this ruling.
It is Sisiano. I can see from the Awuken, say you are still confident, say Supreme Court etna substantive interpretative issue in this one. Just maybe they might rule in favor of your client. This time not your client, or former client, Jetchikwason. We would have to wait for that time. Unfortunately, you're way clear as to when exactly the court will sit on that.
And that's a great disappointment because also one would have expected the Supreme Court will give us a roadmap because it's about representation of people. Into petitioner no one Michael Nifa
Michael Nimfa something.
He's no more important than the over 15,000, 20,000 people who voted for the MP. He's not more important than them. So I thought there would have been a roadmap. Oh, okay, the substantive matter will be heard on the something May, and then we'll give a ruling on the something like that. There should have been a roadmap for us to know how this matter will be determined.
Now, initially, we make here a very important point about irreparable damage to Obia or Kase. Absolutely, the constituent. How about those who argue, say, the irreparable damage, if he continues to hold himself out as MP, would be to the Constitution of the Republic, because a High Court ruling is still there. It has not been contested. It's not been overturned. That ruling would have to apply. And as long as holding itself out as MP, a spite on that ruling from the High Court.
No provision of the Constitution has been breached by his continuous stay in Parliament. And Nuntina Kasa are in the Supreme Court for the interpretation of Article 94(2), which is the main issue in this matter of the MP. So until a court determines that there has been a breach, nobody can say that. The High Court, when they ruled or judged the matter, we went for an appeal. And so the Court of Appeal, notice of appeal and then stay of execution. As we speak now, we are found to relift the matter at the Court of Appeal. You are finally, your friend says, to arrive at the Supreme Court to quash the ruling of the Court of Appeal. And they themselves are in the Supreme Court for interpretation of Article 94(2).
Mm-hmm.
So, who has the power to say that the man's continuous stay in Parliament is a breach of the Constitution? From whose mouth?
The Supreme Court has said that in today's ruling.
The Supreme Court didn't say that.
No.
If they had said that, they wouldn't have said that the substantive matter has been adjourned.
No, I mean, sir, they've said that based on what they said today, sir. The man, because the man should not hold himself out as MP, a pursuant to the decision of the High Court. No?
That is an injunction. But look, you can only know the full length of a frog when it is dead. We have not gotten to the end of this matter.
Okay.
Don't you know that there's a substantive matter?
I know.
Pending?
I know.
So why are people jumping over themselves and talking about by-election? This is 5-4, 5-2.
5-2, yes.
What if we meet today and we decide that there's going to be a review? So who says that the matter has come to an end?
Okay. Now, me pacho, as part of more strategy, will it be something you would consider, say, maybe, just maybe, because of what the Supreme Court has said today, maybe the Clerk of Parliament will take notice and say, we are writing to the EC, say now a seat has been declared vacant and that they should organize a by-election. Will it be part of your strategy to look at that angle as well?
The Clerk of Parliament cannot do that because one person can say the clerk or is it the EC will take notice of what is happening in Parliament.
Yes.
In court.
In court.
Yes. The clerk also takes notice of what is happening and knows that the matter, the substantive matter, has not yet been dealt with. The clerk will take notice of that.
Okay. Lawyer, ma mena se na fe bibia ni a ye besan so ba bedi nkomo bio. Why?
Yo,
Meda se pa nyame nshraw. Enti Lawyer Abraham Amaleba, only a Director of Legal Affairs for the NDC. And Amotesi Eneno AD Nkomo. If you have any thoughts to share with us, you can get onto our Facebook live stream, Asempa 94.7 FM on Facebook. Post your comments there. I would share your thoughts with the rest of the world. Look at YouTube and so are the same thing. YouTube and so your channel Asempa 94.7 FM. Now, Odi Adwin Channel Eguho. And join our big discussions. Nafi yentie wonso wadwenche on all the issues. We say thumbs up to your court reporter. His apt response and reading of the court judgment swiftly stopped lawyer Amalebe's theatrics to play on the keyboard of supporters' emotions to cause doubt in the court's decision. Mr. Kwesi lied under oath at the time of filing for nomination, and that's that's criminal. Simpliciter Farouk in Tema. Farouk, you know, sir, the criminal partner is in court. The court is here to adjudicate on that. Let's be careful the pronouncements we make. We say this is not a victory for the NPP or anyone, but victory for our democracy. I honestly like the courage of our judges in the discharge of justice, particularly high-profile political cases, because it is not the case in many African countries. I'm not surprised that Ghana is ranked as one of the countries in the world with good and robust judicial system. However, it's high time we all supported the Chief Justice to improve the judicial system, especially in the delay of judgment, because justice delayed is justice denied. Okro Yeboah, Ewo Breman Benin, and Onodi Way Abraying. Where's the Obi? On the case of Honorable James Kwesi, has the NDC forgotten a similar issue of the NPP's late Honorable Adamu Sekande of Boko? Dr. Dapaah and Ebu, you would have heard Amaleba say the two are not the same. But he continues, Dapaah continues, he was asked from Parliament and jailed for 2 years. But President Mahama pardoned him after he got sick and was consequently flown abroad for treatment where he finally died. So between the time he was asked and the by-election, who was representing the people of Boko? Look, Honorable Kwesi committed a crime, allegedly, so can't even stand again for MP, period. You think so? Because as we speak, the criminal matter is still pending before the High Court. And the maxim is that the accused person is innocent until proven guilty. And for now, the man stands innocent until proven otherwise in a competent court of jurisdiction. And they say, Basse and say, the by-election in Pobebaso. Na ECBA nomination. Na send a party for a tromana. He can still contest. But that would be a risk or no ebeteki, but he can still contest. Why not? We say, okay, Dr. Dapaah or DC and Awudiwe Abba. This one says, I think Ghanaians should be asking President Akufo-Addo that which of his numerous promises to Ghanaians have been kept faithfully, and he said they would account for the e-levy. First, he should account for the COVID-19 relief fund. Ablade Ewo Efie Kuma Zango and Odiwe Abba. This one says, okay. I say, Obi, please let the technicians check the streaming on the multi-TV box. It's been on and off. Okay, I hear you. Thank you. Inti, our technicians who will take notice and move in. Now, Obi, good afternoon. Please wish me a happy 51st birthday today. I pray for good health and long life from Yao Ej Sebastian or Amsterdam. And the happy birthday to you, 51 years and you're easy. Live to be 94.7 and beyond. We thank you for always listening to our show. Yao Ej Sebastian or Amsterdam in Holland. Happy birthday to you. Let me see. So the Supreme Court is saying if even you are not sworn in, you can call yourself an MP because you won the election. Sir, my problem is, at what point in time does one become an MP? Is it at the time of filing or at the time of having won the election or at the time of having been sworn in as MP on the eve of 7th January? Peter Light comes in, former DCE, Ejumako Enyan, SCM, and on the questions we are praying. We say, Obi, what type of argument is lawyer Amaleba making? Didn't he know the rules when he applied to be an MP? Ante L and so question. No. This one says, what's lawyer Amaleba saying? Is he aware of what happened to Adamu Sakande? If yes, was he guided by the same principles he's having now? Hashtag Ebefa. Or no, no. May and then I'll come back to your messages. Lawyer T Hammond, MP for the Adansia Sokwa constituency. Lawyer, akwa ba na pom to saying. Adumia the crying kakra. And me did say we follow the Akoso Ewo Supreme Court ruling. Of course, you benefit of the detailed ruling, but at least directives on my what TB, your colleague MP, Supreme Court say emanating holding itself out as MP bill, at least until the determination of the substantive issue before the court. Eto saying me pacho.
As I'm not saying you'll be there's a woman MP na say that. But I'm not who be the MP Amra who president Amra who Yagma was some part Amra who didn't run so. I can't copy High Court. High Court to say, only a court of appeal. I almost come back no more. What may we want yet? Some baby, and so on. I consider. Otherwise, I'm a catcher of the if you say by January, January 2020. And I know January 2021. By Cotton, by some kind of no more. I think I'm a baby. As a man, why I can't baby. So only been a year. And yet, but quite a in the primary, so quite an election where we need or buy a swearing in as a member of parliament. I say, long cotton of year. We are in your but I'm running a year. Since the room got the come once a month. The room got the council who did to me. I want to be as I can year. Yeah, but lawyer Amaleba is of the view, sir. Since the substantive case, said the court Nankasaka and no, sir, the substantive case is still pending. Now, almost say parties never file processes. Be now for the date for the determination of that case Nankasano Abba. Since I know yet pending, no, on if you say any fair for the court to injunct the MP, say on to me holding itself out as MPBO when the substantive case is still pending. Is Lord, as a law, then because the law is not a logical or in attempt as one actually a law logical. So whoever says a law near fair, no, I don't know. But it's the law. I mean, we're not talking about morality. We're not talking about fairness. We're talking about the law. Law now, you know, fairness. But law pronoun can say, now I agree or say fair, fair. Law was the own concept of fairness. Was the own concept of logic. But in the end, it is the law. Into those, I would say, fair. Well, that's how you see it. You know, but okay, I'm saying more can make questions. Now it's a breach of the constitution. Also, I say no. It's a crash in the parliament. Na community power. I say no. I don't know yet to say I Salah case na chat movies as a group no. I don't know. Actually, what I said, I think he was the chief at the time. So good continent Salah case now movies are. But you offer law school, you know, what certificate, you know what I'm talking about. What we're asking is, you know, group no, I know, I'm a cast, no, I know, by my company, I didn't know business at all. I say no, but that's not it. In the end, it is the constitution. Election petition starts from the High Court. Every High Court, the law goes to the Court of Appeal. It did a Court of Appeal, and the matter. It seems to be without anticipating what Supreme Court must have said by way of reason, you know. We have Court of Appeal. It's fine now. We have though has come up to us and say, any interpretation of 94 2 no, dealing with say. They say what we are dealing with is what the Constitution mandates the High Court to do. Now, if you are court of appeal, all my we are holding in a baby and who you. And as far as they are concerned, the area no, and on court, So as a man, maybe man holding himself as MP, my view, that bit is complete. Fair. That is view, but the bottom line.
The other thing, and it's per the directives given by the Supreme Court, does it necessarily pave the way for a by-election now? And with the experience, no, at saying.
No, I see. It's a little difficult, but ultimately, I don't think it's that's what. Else they would have actually said they would have mandated the electoral commissioners on Koye. Also, I think that but mostly almost pending.
Yeah, pending the determination of the
now pending or what they are not to about now more man can be released as they say. We got to a by election, now we pay the bar for the pending as we need another elections, must I come and now one so we have a causing financial loss. The court thing never come home. So I think essentially what he has said is yes, as artists, you're really the amount also all that there is to exhaust to the Court of Appeal level. That's the Constitution. It says some matter will do over. And on Tennessee. But Moody be about but for the time being, I don't think the electoral commission is a by election. Other than that, almost outstanding, it's not assume your friends say court workers will lose. It's others who will lose, others who will win. Or we need high court appeal. What the man will be back in Parliament. You ought to me and the electoral commission was something substantive pending before.
Yeah, but just to draw your attention, Honourable, sir, even at the Court of Appeal, Omun said that exhaustive court need throw more matter of the notice of appeal out for non-compliance. Inti Utia Maleba or Masia realistic that particular issue now at the Court of Appeal. The Honor Crown Omunya.
No, so I point you see the I can't say, never be able to say. She says, what you know, she says, no one here can watch them. The issue is that at the Court of Appeal, said yes, we all know what happened. It didn't say, well, you're doing yes, say. That's right. I'm a court and say, well, want to me, yeah. The particular phraseology, I think in that paragraph 20 or so, it might be I can say it's being struck out, So striking out, yes, you can read it, but as it is, no one really see you, don't really see you. And by no, there is absolutely no effect. Any injunctive effect, any substantive effect, nothing. Why your application say, what's realistic? It's for the court to decide on whatever they want to do. And automatic. I read many cases. Could do one court and say the circumstances are such that they don't really full stop. And not be so unrealistic. I'm not in itself serves no purpose. And yes, that's what we're talking about. It doesn't serve any purpose.
I like the bit about where our car said. Say court in their directive they can pending there. Not just say you don't agree, and I say you don't believe say the EC can step in and organize a by-election because substantive case no either so ever. Don't you think say don't you think say for that same reason no in the court then asking him not to hold himself out when no meaning the substantive case no is still pending no a hono na be a maleba free say a court na nsheda anya de. Based on that same reason.
What was the court hasn't been fair. My guy just said the court has its own, the law has its own concept of fairness. My just said, as far as the Supreme Court is concerned, case now could be an election petition. What is before the Supreme Court now is not an election petition. The election petition, the High Court. You don't have the right of appeal to the Supreme Court. Until for them, the election petition is over. A constitutional matter is turned up. say we're asking for interpretation of 94-2. So the Supreme Court said they would take up that one. But they thought about it in their judgment. I think they almost don't say, okay, what's the election? Election this year. And I just say that for all intents and purposes, the election petition is over. But there's something substantive, which is a constitutional issue now, man. You know, unfortunately, but yeah, man, election. Yeah, unfortunately, I don't just say it's unfairness. It might be unfair. It is how he sees it. But my children, the law over the concept of fairness and unfairness. The law says there must be an end to litigation. This aspect of the litigation has come to an end. Well, this full stop. And that part now, but that is without prejudice to the constitutional imperatives and provisions. Actually, a particular matter should end at a particular point. This one says starting with the High Court. I was saying end of court. You conclude and years every home. And no nonsense as one say continue. You know, you are saying that almost substantive work. Because woman and woman say what never na back when you be never. I won't say once another America. No, review. It is a constitutional right. We are not on Panama, the match of say, unfairness now, what you know, arguing and more the issue of unfairness. Now, one piece a grant for review.
Counsel, with years of experience at the bar, you qualify to sit on the bench in a superior court, Ghana. Imagine, say case way about because I gather just to see as a sure.
Why do you also make a contempt of move to another topic?
No, something can't top me question.
So move on.
No, question, Ben. Me musa question, honorable.
I was Obi.
No, in simple terms, say ye kase ebia 94 kase a person shall not be qualified to be a member of parliament if he owes allegiance to a country other than Ghana. The be kase ye kase before election no started from time being. Do you have an idea with your experience?
No, I have an idea because the Supreme Court has ruled on that. The letter is very clear. Some of us the letter is very clear on that. Go and read the letter. In fact, the High Court judge, you just speak in Aquarian is the letter. Or the letter decided. Say, it is one electoral commission, one other man, one started a qualification, one started, so it's clear.
Adomano meaning nomination period, no?
What's that?
Adomano meaning nomination period, nah.
Oh boy, it's a time so one starting my nomination, one starting say, we're starting the process now leading to election proper and yet when the election itself is held and not when the results are announced, now the no. That is my referee starting November. So the letter is there. How much decided on where so if you are saying but it seems to me that is the reason why this matter is back to the Supreme Court. This is one of the issues of we decided. So kind is the letter. It doesn't apply to this one. Remember, the letter one was not really 94-2A. I think
the Americans is here near 94-2B. I think a 94-2A owes allegiance to a country other than Ghana.
No, the other will be 94-2B.
No, B.
No, they are not the same. Back when different. What's the constitution?
No, Zeneto the NA 94-1A.
94-1A.
He is a citizen of Ghana, has attained the age of 21 years, and is a registered voter.
That's right. So that was about the registered voter.
Registered voter, absolutely.
Yeah, that's right. Now we're
94-2A.
Yeah. So we are saying we by general ruling now, it's the same concept. We think that that's what the Supreme Court said. But if it is like you said, the matter is back to them. The Supreme Court. They will clarify that.
They will clarify that. Okay. The other thing I'm saying, a former colleague, and the National Security Minister, It's reported to have said, and in fact, you're born a voice, no ewaha.
Kamiche ya kebe me defa. Me obetumi abo mbeti. E ware dodo. Apart na no obetumi abo.
And shut down wasa. True mume voice ma me na me mona.
Hear me pa.
Yeah. I'll play it back now.
Now what?
Say again.
Former boss.
Me say o former colleague.
You former colleague.
Hey.
Oh, you're a former boss.
Na say na only in our parliament ana.
Won't hear the American. Me say I'm a boss.
Okay. Our energy ministry, I suppose.
That's right. He was the first energy minister of the administration. Man, no, can crack and climb here.
Now that
on for all the petroleum sector. Also electricity power near digging also until the deputy so or the mayor substantive that me. Na for my admission, we get that where that's what I mean. Activities are admission. Os mama men ko net me ko see my brother report every there are some ko obi o one of the car hit your contortion where this car contortion this car. I mean actually in that man.
Okay, I have the voice now, Honorable Inti. Where Yenti ya ba na di hunko. Mate.
Injustice occasioned as a result of the absence of an effective justice delivery system or delayed justice or biased justice is certainly a threat to national security. And indeed, when injustice abounds, particularly in situations where the bench, which is considered as the final arbiter of disputes, is deemed to be biased, citizens tend to take the law into their own hands, most times without recourse to the established systems of justice delivery. And similarly, the failure of the criminal justice system to ensure effective and expeditious trial of criminals adversely impact the morale of law enforcement agencies. It also emboldens criminals to perpetrate more crime and breeds lawlessness among the citizenry. Developments which threaten the internal security of the state. If you are going to be able to address the security challenges that we have, especially the domestic ones, we need to be able to ensure that there is a judicial system that works. If you do not have a system, a judicial system that works, many people will simply take the laws into their own hands and misbehave and do what they want. Therefore, in trying to manage the security situation, it is important for us that we do get a judicial system that works. And we are all lucky that in the sub-region, we are perceived as a country where the judicial system works and where you could expect justice. If the interpretation of the law is tilted so much in our favor all the time, people will start accusing the judiciary and will not have the confidence that they need. Injustice occasioned as a result of the absence of an effective justice delivery system or delayed justice or biased justice is certainly a threat to national security. And indeed, when injustice abounds, particularly in situations where the bench, which is considered as the final arbiter of disputes, is deemed to be biased, citizens tend to take the law into their own hands, most times without recourse to the established systems of justice delivery. And similarly, the failure of the criminal justice system to ensure effective and expeditious trial of criminals adversely impact the morale of law enforcement agencies. It also emboldens criminals to perpetrate more crime and breeds lawlessness among the citizenry. Developments which threaten the internal security of the state. If we are going to be able to address the security challenges that we have, especially the domestic ones, we need to be able to ensure that there is a judicial system that works. If we do not have a system, a judicial system that works, many people will simply take the laws into their own hands and misbehave and do what they want. Therefore, in trying to manage the security situation, it is important for us that we do get a judicial system that works. And we are all lucky that in the sub-region, we are perceived as a country where the judicial system works and where you could expect justice. If the interpretation of the law is tilted so much in our favor all the time, people will start accusing the judiciary and will not have the confidence that they need.
Asempa FM.
Lawyer, me ba talk say ote voice na dey. Great. And your thoughts, me pa cho.
When you can na mantem say Kan Dapaah a law court go group bi the MPP nti mo mususu room MPP na no me wo bochire me na our party bay.
Yes sir, baby your car say if the interpretation of the law is always tilted in our favor.
Our no.
And send you also no catch rain.
No one na catch as no no kai no ya wo kai ni wa ba chire bi sie ya you know our na wo bro fu no kai mu no represent one mo.
Minim
I hope you win say wa bro fu what year wo so wa ba chire be law school na wo no ya dey fund.
Okay.
Fund ni ya dey win pa. So obi what friend say asma me from the national security minister or can o baby I can baby then I say mutie ya what say British Parliament, the Prime Minister or prorogue Parliament, the Supreme Court overset it, acquire some Parliament debating you see or what. This terrorists and your man, of course, one yana laws. Bayan says laws be for moon to them, and fire one to or more, a lot of things. Now, do bad, yeah. A matter that could be a court. Could be a court who will view your car. Security forms who will do the car. In one particular case, yeah, Omudi, number one, which over Lord Hoffman, 24 Judge, I can say I could have no power. Now, something say, listen, judiciary, yeah, said Yakaka. Yeah, and Dimra, but buy who boy, yeah, buy. I want to security for. Which is to do almost some about. Yes, could be criminal. I say, I was at national security, yet tea and in papa. And here, well, British system of, and it's part of the common law. Say, it will be a friend of the margin of appreciation. And normally be banner, yeah, the judiciary allows a certain margin of latitude to be, executive, no. Judiciary no woman now homo kwatere abronfo no woman na kwache terrorist no parliament no woman di omo ashemra no woman na kwache womo no woman na kwa yewi a police for national security womo hono MI5 MI6 Scotland Yard security for woman so the court been very, very careful. I mean, the highest level that time the House of Lords is now the Supreme Court of Britain. Almost be very careful when it comes to the executive decisions. We say, but that is not to say a bar court or mobile happening as so. I buy a question of what I see for me. What Kan Dapaah was saying, they say, motion ye. National security, man who by, Mali, at the end here in Echo, my family, some of the count, me about Burkina, the other count, what the young Ghana, hey, we want to come to Buha, we want to do it, we say, we keep back in the national security, I cannot mean, I don't know. And she said, "Be more bread, mature meaning almost actually, also almost for the security network and no man, no more, fast, what take, and it's maybe I'm son of fun, or what you actually depend on. What's here? What means no, that's not the go to no to watch the panel. Already, what never when you actually by one evidence, you know, the Abba, you probably actually at Naba. Mummy asset. I say maybe I said maybe in the court is I will use you and you face technicalities there. Yeah, lawyers here technicality any more than getting a lot of zone. One now what I technical or physical case prepare or do what one small and you know about pam. I technical now go to what we need. You know that you have to court technicalities are part of our laws. The national security outfit no only what you only said you almost don't support. What would I have me about keeping that? I give you a classic example. What Grant said in England, I would be actually the court anymore. That's what the prison one there. Yeah. Over to say what that young prison now, that police, you know, police cell hold more cancer. You know what we're doing? No man sex, you know, they are record one, and what can your person over no crowd walk out. Obi adu wanu obi dey din komo say wa kan nsem ni record ni now say fei wo dey na kofa sa record we say na de ba say well na so na ye ono na wa kan ni na no eni e we ya e port is say na mo bag ye na wo ji sa mo meche it's not admissible. That's for the national security wo ya wo do mo so ko mo ye ura di yankopon ya chen ko vote ma wo mo akọ ma say me ya chi we dia ba court say evidence I'm obtaining illegally. Oh, yeah, such a yeah, England, you have the police and criminal evidence in 1984 page. Okay, can you do that? I say, oh, my people put your yeah, you know, admissibility of evidence in the one. It's, you know, the Kan Dapaah in this statement is saying that Omani Oma, I was a court to the fair to be and you know, on court no and get to be to have water or better. Where's our no so yeah, national security. Remember, I'm told that the Chief Justice himself was there. Yeah, or say almost road towards enhancing, you know, national security or so what kind of said the case and more no almost the sign by now okay I've run to record no matter what is saying to them is that Obia will go. Yeah, I said court force with the rule. It's true. Yeah, the other and your fair. Yet she says a mom and I your fair now move attention and no could see a source of national security concern. As you know, we are not, we are some now, we are attention. I don't under security. What about your say? Which say West Africa, I got to say Ghana, but then he makes the point. He said, but yeah, the back, let's say more to go there. Almost Russia, make a drill, almost your name as a Farano, Faba. That will do baby, and I go what not who was a woman flag jacket, and woman's a flag jacket. Now, woman, what is made of? Say, only ambush of Obi and the rest of their lives. So, we here the back of the court to say that we might get it in much of Obi can. So he was saying that this is, you know, the court should look at it now, almost get your mayor. Then, so, well, if you rule so much in our favor now, or say, yeah, national security, this is what we are saying. We are pleading. More technicalities, you know, and also, about national security matters are more technicality, you know. Someone money back we don't know say national security matters are entirely different matters. They will be I know they are money, but we also not say in say just as why the baby I'm say papa say in my Obi a small card you've been so much in our favor. We the national security now here pleading with you though. We also tell you say yes, yeah, can't say money my And also say ya wish I get him wish I would be was on the car. I was at never morning and never morning be or run at the end of it. Now they double the car home, what the ones who come, which I know I get today, you know, say, yeah, my wife. Now what you could do a part. Say, I do my, yeah. And no sooner than here. Then you had baby Mundi and Tessa, yes, I was one. No, so a pretty national security. Because I will get your maid. Obi, they may have the Benedria, which I was to be back out. I got over the bishop. But now, that is a source of national security.
Yeah, but honorable,
that was Kan Dapaah.
Honorable Sadia Wokano, not or boss. He's an experienced person. Why a national security minister? Ne 5th year or 6th year muna owi. If he wanted to say, as some said, you will canona. Sanko Becca won't create any ambiguity be around the issues. There are no, because on one so it's not on, he is wearing 3 hats. 1, or a member of government. 2, he heads a national security or say National Security Council, so which the president chairs, or a member of the ruling NPP. And in such matters, I am not contesting so in here. The contest no and say the current conversation around the injustice delivery has been around political issues before the Supreme Court for interpretations and the can especially say and a unanimous decision they be a 7-0 9-0 in a honor I formed that perception say maybe the court no seems to be doing the bidding of A or B. It is a orcasa about when interpretation of the law always tilts in our favor. Isn't it in line with our, perception?
No, contest now, the man with all the experience, many years of parliament, national security, or your minister for the interior, or your minister for the defense. Now he's the national security minister. He was speaking before the top echelons of the judiciary, Supreme Court, Chief Justice. They were all there. How could you assume that he was telling them, you should also look at the contest now, okay? Who say one with your kind in the contest? Most more more than Lucy Bonnet, most more contest. Or talking to them not as the MPP government. He wasn't talking governmental. He was talking national security, protection of MPP for, protection of NDP for, protection of CP, protection of PNC, and you almost Obia. I'm the million Japan also the Tea Party, also Venabro. That party, I'm wrong for so the other it's even so I can say in my capacity of national security, I'm saying judiciary, there may be only I said, gender problem, and I said it's difficult for national security. I am here, Kan Dapaah national security, and Obi Uti, okay, now was it national security, and then as he, the boss of national security, that into it. Yes, we've been talking about 7473. Or 7473 as well, can say it will be by what you want near the Omoba. Now, you say technicality. Use the phrase technicalities. What the technicalities near about me about yeah, lawyers are here. The case is about first one. I hear the baby. So they have actually the accord the technicality with him. Obogus are not you, baby. But for them, technicality, I did this and I did this. So Shannon Quade, Bromo Bre, near what you will be at Naba, that's a technical Yagani Pacorona, and so on. He never talked about MPP, and that wasn't the point he was making. To one more critics are contest, no, or when you free war, or Yapada, yeah, who then a Casa, or Musu, my head, my head, Yama. Now, the Yama, and then I want to open your bedrooms. I don't want to Monteso.
Okay, and I guess said then maybe lawyer Ayikweyo Tunso did not get the contest right from your perspective. Said he made a point. Onona throw in the thing say Honorable Kan Dapaah kase say court no edi cases ebia 3 in favor of MPP a ochina omumedi 3 in favor of NDC nso ana ba asem na o kan
Bankarza bra ikwe wa but that is the point. He was there as a national security minister, and then the security, and then technicality. Too much in our favor. Yeah, security for now. Yeah, can say sana mon kama yeah. Say mon to mo wasi na mum. I'm also saying you can't say just that you are mon kama so much because there's also on the back of what in fact a make it another Indian penisa. Be fair to say na mo fairness na work and court no. Baby well can you too quiet the idea to me Ghana you ready to say integrity that's so common law countries no Ghana you too young kwada it's waka abo mo abaso but war I'm telling you in England it happens this judgment they make that me hu na ba no obo right Robi or also say okay Lord Hoffman and others say look we should yeah to how and some no home the me yeah and to me your smell she say when you bomb or to technically to be it is there case no amount citation because maybe amount citation and or in good company we caught the Kan was asking, someone, but I know I'm demoralized. Now you know the effect on the demoralized force. That's the point he was making on behalf of the troops.
Honorable, may I not say fancy? Bibiani, I best have a bidding comobio. Why? Yeah, that's in Yamin Shroud. The Honorable T Hammond, or a lawyer, MP for the Adansia Sokwa constituency in the Ashanti region. Ekosi saying Sony, a higher Sempa 94.7 FM, loads and loads of your messages that have come through. Yabeshe na yakai kakra ama monafe yetumi atwaso edoso ankasa. But this one says that Obi, good afternoon. Kindly extend my well wishes to Nana K as he's contesting for the first vice chair position at Asante Achem South constituency. Nana Kojo Eje, popularly called Nana, is too down to earth. Okay, and always willing to support the grassroots. Munkaila Jonas Adia inside Kerry and Odiwe Brain. Obi, please, if the Apex Court has affirmed the Cape Coast High Court case, then is it possible that the parliamentary decision made on the night of 6th to 7th January 2021, with him, Honorable James, which Honorable James was part, can be challenged? Ajingo Papa. Ajingo, question, no, I don't know. But I'll say, good day, Obi. Kindly wish my blessed daughter, Neraya in Shraba Ablodepe. Hey, Ablodepe ne dome di edin omo de to omo ma de obo. And Ablodepe baba ne freno Neraya in Shraba Ablodepe. A happy birthday on behalf of her parent. With love and hugs, we say a happy 4th. Hip 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 hooray. Thank you very much. Samuel Ablodepe and Onodiwe Aba into Neraya in Shraba Ablodepe. Happy 4th birthday to you. This is a special one from your dad. Do have a good one. Obi, was lawyer Abraham Amaleba in Ghana when Adamu Sakande was sentenced to prison with on a similar issue? I don't understand why the NDC are crying over this MP's judgment from the Supreme Court. May Adamu Sakande soul rest in peace. What is good for the goose should also be good for the gander. Mr. President, Denmark. Obi, the minority knew from day one that this man was going to lose the case. I pity him because his own NDC are wasting his time and will deny him finally. Regards to Emmanuel Akwa, Regional Secretary Hopeful Western Region for the NPP, Gastiman Brekum. Okay. We say, let me see. Obi, a happy birthday to Mr. Samuel Soa of the Passport Office Headquarters, IT section. This is from the Mountain Movers Group to you, Samuel Soa, or Passport Office Headquarters. Happy birthday to you, and do have a really good one. Live to be 94.7 and beyond as well. This one says, may God bless you with love and care. Enjoy every moment, every day of your life. Happy birthday, Nana Kofi Eyisi Ansa. And this is from the Nigel Foundation to you. We say, good afternoon, Obi. Please allow me to use your medium to wish my kid brother a very big happy birthday. He is Richard Kumsin, a final year student of the Takrady Technical University. From the entire family, we say God richly bless you. And God willing, tomorrow, our father, Mr. Edward Kumsin, will be 62 years. All we say is, thank you, Lord. Edike, ewo efie koma, new scythe. A new side, that's in Takrady. Happy birthday to George Quatin of Adenta. This is from Sir Obama. And he again says, Obi, today's ruling by the Supreme Court is a victory for democracy. End of discussion. The bleeding can continue unabated. Regards to the incoming NPP National Chair, Stephen Ayinsu in team, and the hardworking General Secretary, John Adrinkesiye Buedu. Obi, election is a process, and we all know that. Can I apply for American visa and without seeing the approval, I run to buy a plane ticket, hoping the visa will be granted? That's exactly what the NP did. At the time of filing his forms, did he have the certificate of renunciation? The answer is no, and that settles it. Nana Amponsa Bidiako and Odiwe Abrain. We say, Obi, good afternoon. In my humble opinion, the ruling of the Supreme Court today will serve as a lesson to the minority in Parliament, especially the Honorable Muntaka Mubarak. I see no reason why 3 members of the majority will be referred to the disciplinary committee for absenting themselves from Parliament for 15 sitting days, which the law is clear on. And Honorable Muntaka is the one defending them. No, I don't think did Muntaka really defend them? I think we have to be fair to the minority. The minority member did not defend them. They were kind of say the processes adopted by the speaker and against. I don't think that is a defense of them. I might be wrong, but at least the MMT and Honorable Kujetwa Black was doing common. He told us his leader was against the process adopted by the speaker. That cannot equate he defending the honorable members in question. I don't think so. Or say it is time the minority in Parliament stopped playing with our intelligence, because we can read in between the lines. Obi, in my humble opinion, the NDC is to forget about everything and let's go in for the by-election. And I can bet you with my last penny the NDC is going to win based on the abysmal performance and hardships in this country. Alhaji Hamza is in Pig Farm and Odiwe Aba. Obi, comparing the case of Kwesi to Adamu is not on. Kwesi, he did not lie about his citizenship. He renounced his citizenship, but due to COVID, it delayed on the part of the Canadian authorities. He did not lie to the Electoral Commission. The EC accepted and cleared him pending the final certificate before December 7th. He received the certificate in November 2020. He contested and won. He was sworn in as a full Ghanaian on January 7th, 2021. Eugene Ishen Elliott. Edia Ode Abreye Eni. Obi, what's Honorable Amaleba saying this afternoon? For me, it sounds refreshing to hear that the Supreme Court has upheld the ultimate application of the law. The Constitution is very clear on this, as it happened to Adamu Sekande. Justice grinds slowly, but it will surely be delivered. The Supreme Court judgment was very clear, and we would not need any voodoo explanations and analysis to understand what happened today. Fawaz Inamasaman, incoming constituency youth organizer. But the constant comparison between we and Adamu, and that's what Eugene Shen Elliott said. They look different too. We say, Obi, if not for your court reporter, lawyer Amaleba was just about to jump into drama and some legal propaganda. The fact is clear, since the Supreme Court has ordered him not to carry himself out as MP. Neither can he perform parliamentary duties. All of a sudden, it's a dent on our democracy. Who says so? None but the NDC. James Jachikwason should have listened to some real legal pros than allowing some of his party people to lure him into this. Onel Amponsa, Amsterdam, and all the way a brain. Message is not a door, so but let me do this. I'll come back to the messages. We say, Obi, today history and precedent has repeated itself at the Supreme Court. It is sad but too late for the Asin South MP. But I blame the NDC national executives for allowing this illegality to go on at the vetting in the first place. Kwejo Edupako, Ewo Achim Eswum, and